Hello guys, welcome to part 4 of the legal jurisprudence series. In today's session, let us going to see about the what is meant by justice, administration of the justice and the theories of punishment. So now let's begin. And before begin, I will tell you that this is a non-monetized channel and just for intellectual pleasure. If you wish, you can subscribe and share, like whatever you wish to do. Otherwise, no issues for me. Okay, let's begin. Let us begin with the concept called justice. I hope this board might be inconvenient to you. Please make sure I have only this much size of the board. I don't have the large board enough for things. Okay, fine. Please adjust. Please, sorry for my inconvenience. And let us start with the justice. What is meant by justice? Let us not rote learning thing like what is the justice. I'm going to give the definition. No, let us analyze. Let us understand deeply what is meant by justice and how the justice gets function in the society as a whole. Okay, if I have to tell it in a very layman term, I can define the justice as discrimination between the right and the wrong, accepting the rights, negating the wrong. What is right and wrong? So it is very much different for the different kind of the time and different kind of the society. Like it is a very much time dependent factor, like any other factor. Look, so now let us take. I will give you one example. For example, if A person commits a murder to the B, so A is given the capital punishment for sure because he killed the B. That's why he is going to give the capital punishment at the contemporary time. I will give you a very hypothetical example to understand the justice. I will give that opinion to you regarding the opinion to you. For example, like I hope you all watched Interstellar movie or something. Let us take a hypothetical imagination in this whole Earth. Only 100 people remain survive. There is a lot of climate change, lot of factor like lot of drought. You cannot grow anything and everything on the land. So that is a huge famine taking place. And some people get to know that in a distance far away region, so some land is there where you can able to cultivate something. So they want to travel. Only 100 people survived. For example, there is a 50 men and 50 women. So they want to travel over there, but they don't have enough food for them. So what they do, they thought to kill at least 20 people so that whole humanity gets survived. 20 elderly people, they want to kill them, and so that 80 people survive, whole humanity get thrive once again. So it is just like a movie, hypothetical imagination. Sorry, yeah, the what is the opinion based upon your discretion of conscience? How you think about the justice at that time? What is justice? So killing is wrong. Killing is not regarding as a kind of the justice just system, but the at that time, is it killing is the justice? For example, a terror attack happens in the Taj Hotel. What happened? And we killed them. We killed the enemy. If come and infiltrate, we kill them. For example, my personal defense, if anyone entered my house by holding the weapons and if he tried to shoot me, I don't exactly kill him and tell that it is for my defense. So I can claim it as a defense, and I will definitely going to get the case for myself, win the case in that such kind of system. So at that time, how we interpret the justice? So justice means what? When we think in a hypothetical way, we could able to uh, uh, we have to give the justice a more multidimensional in nature. For example, so justice is about discriminate between the right and the wrong. If you have seen the Mahabharata, that is a very much great example where Krishna tell him to kill his own this one relatives. That is what that is called as dharma yuddha in Sanskrit. So that is what discrimination between the right and wrong, and do the one duty. That is what the dharma is all about. How you decipher the kind of the things, and how you make the just at the moment of the time. So it is all about the time dependent factor justice. So I have already talked in the previous sessions or previous classes. Justice or a legal jurisprudence is interpretation of the law. So justice, what is justice? Justice is the ends of the law, not a means. So our constitution, our political system, our judicial system, all is having the common end. That is what that is to build a just society. When we look at the preamble, there we the people of India solemnly resolve to secure India into socialist, secular, democratic republic, and justice. One sentence comes, that is the justice, social, economic, and political. That is what to establish a just society. Just society means what? A fair society, a fair system of the society. So justice cannot be simply in a layman term. I can define discrimination between the right and the wrong, but if I have to define it in a very appropriate manner or a legal tone, if I have to give this definition, you can use even in the exams. You can use this definition, or to understand the justice in the legal jurisprudence, you can understand this definition. Justice is a rational, ethical, and socially acceptable ordering of the rights, duties, and power so that human dignity, fairness, and social harmony get protected. So justice is ethical, rational, ethical, and socially acceptable. What is that? What is ethical? What is rational? For example, in the previous time, Purda system was prevailing. Means you have to cover your whole head, but it is ethical. But legally, you cannot tell that you have to do like that. Okay, it is not illegal, but non-legal kind of the things. Okay, rational, ethical. There are in some societies, drinking is not ethical, but it is legal, but it is not ethical. It is beyond the moral conscience of the society. In some society, it is ethical, also legal. In some kind of the state, for example, if you go to the Gujarat, the alcohol is banned. It is illegal. Literally, Bihar and Gujarat, it is illegal. But if you go to the Goa, it is very legal and ethical. So in Bihar, in some region, it is there are traditions, they consume alcohol a lot. So it is ethical as well as legal. So there are socially acceptable. The society needs to accept their system. So that the acceptable ordering of the rights, duties, and power. Rights means what? It is a interest of the person. That is what is right. Right, when we born, it is legally recognized and accepted system. So when we born, we have naturally have the right to life, liberty, and equality, which our democratic system considers so. So rights, duties. If you read the Article 51A, we all have some kind of the duty. We need to, in the family, we have the familial duties. For example, to look about our father, mother. So if you go to the society, we have some kind of the duty. So duty is we abided by the duties, and the power, so that the human dignity, fairness, and the social harmony gets protected. And this is the most acceptable or a suitable definition of the justice. So when we look at the justice, when the judicial system have to provide the justice, when the lawyers have to defend the client, or a lawmaker have to make the law, they need to acceptably this one. When the lawmakers needs to make the law, when the lawyers defend for the client, when the judge, when we give the justice, it needs to look at all kind of the dimension and then give the justice. So justice is a part of the end goal, not a means. Means all kind of the political system all intended towards the one end, that is to provide the just system or build a just society. So now there are two types of the justice. The first one is natural justice, and the second one is legal justice. What is meant by, I hope you all got the definition right. And now what is meant by natural justice and what is meant by legal justice? Legal justice means it is codified in nature. It is implicitly written in the book. For example, CRPC, IPC, the constitution, it is a law. So fundamental rights, it is also a law. It is a legal right and legally recognized by the state. That is what the legal justice is about. And the principle of natural justice, it is explicitly written. It is also based upon situation or a circumstances. There are a set of the principle is there. When it comes to a legal justice, Salmon, one of the legal scholar, he gives one wonderful definition. He gives that the rights of the community get protected by the physical force of the state. Rights and liberty of the citizens or subjects get protected by the physical force of the state. Means what? Means if I threat the liberty, I have full expression of my own liberty. But if I have the right to travel to all the places, I can do anything and everything. But I don't have any right to hit someone. If someone is traveling in the bus, I cannot pelt the stone on the bus, or I cannot pelt the stone on the bike. So what it happened, it will threaten the liberty of the others. Salmon says that Salmon, the law is always, he's a positivist. He believes in the positive law. Positive law means, I already explained in my previous classes about the law, regarding that when the state makes some kind of the law, there is no ethical, moral, or a habitual consideration regarding the law. Whatever the state makes the law, that is only considered. That is called as positive law. What Salmon talks about is that protection of the rights of the people. That is what the legal justice. Legal justice means highly codified in nature. It is enforceable by the state, or a parliament makes a law, and that law we need to abide by that laws. If we don't follow the law, there is a sanction. We need to pay the penalty, or we are going to get the punishment for that. For example, if I do some kind of a criminal activity, or if I do any kind of the crime, so there is a punishment for that. That is what this one legal justice is. It is very much implicitly written. When it comes to the principle of natural justice, for example, in that AK Kripak versus Union of India, this is the one of the classical case. The fact of the case lies like that. In the fact of the case, in the AK Kripal case, what happened is the person AK Kripal, he himself is the part of the selection committee who chooses the candidate. Candidate is also AK Kripal. In the selection committee, also he is the judge of that system. So finally, it go to the court, and the Supreme Court tells that there is no law such kind of you should not be the judge. But Supreme Court, what it used, it did not use the civil procedure or something, any law. It relied upon. It relied upon the principle of natural justice. What is principle of natural justice? Principle of natural justice talks about there are various. There must be a fairness, must be that the two parties are there. Two parties must be heard, and no one should be the judge for himself or herself. Okay, in that it applied that no one should be the judge of himself or herself. So he became the part of the selection committee. Candidate also himself, just like I am writing the exam. Evaluator also, myself, I became the evaluator for the same examination paper. So that is contradictory to the principle of natural justice. That is what the principle of natural justice talks about. There are two types of the justice. Legal justice means, for example, fundamental rights, this one, universal right to vote, this and all written in the constitution. This and all legal justice, IPC, CRPC, everything comes under the ambit of legal justice. Principle of natural justice mainly used in environmental laws, dramatically used. For example, environmental tribunals are there. That tribunals works upon the principle of natural justice. It is not abided by the Civil Procedure Code of 1908. So that is what the importance of principle of natural justice. When we could not able to give justice fully by using the legal justice, the court follow the principle of natural justice. So both are important. Both are a part and parcel of the justice system. Okay, now let us come to the types of the justice. What kind of the, for example, if I commit any kind of the offense, what kind of the this one punishment I am going to get? There are two types of the justice. One is criminal, one is civil. For example, it is a very common sense that if anyone kind of the contract is there, if I don't pay the taxes, if I do any kind of the public property, if I any cause kind of the any harm to the public property, I will write in the civil code, and that is what the civil justice is all about. If I do any kind of the crime, it is considered crime as against the society. So main intention of the criminal justice is to punish this one person. So it is considered as not only against the victim or individual. If a person is commit a kind of the killed B, it is considered as a committed crime against the whole society as a whole. Okay, fine. In the civil justice system, there are two parties is there. So when you look at the all kind of the criminal cases, state versus some X person, state versus Y person, so such kind of is there. So public prosecutor will defend the cases. So such kind of, that is what the criminal justice is all about. So in the civil justice, so what kind of the wrongs you have done? So criminal justice main intention is to punish the person, wrongdoer or punish the person. This is civil justice is not only punish the person, to make the law obedient. For example, if someone break the contract, so penalty will be put. But here no penalty. Here some kind of the punishment have to be come under. Penalty is also there. Punishment also will be there. Okay, fine. Then the theories of punishment. So now we have come across what is meant by justice, what is meant by natural justice, and what is meant by legal justice. So major objective. Now before going to the theories of punishment, now let us look at into the objective of justice. Why justice is needed within the society? The first this one objective is that to maintain the social order and social harmony. Every kind of in the society, some kind of the order is there. For example, there must be a social clash between the caste, creed, religion. There might be a clashes taking place. Some kind of the social you need to maintain, law and order you need to maintain. For that, justice system is needed. And the second one is to protect the individual liberty. So individual liberty is the cornerstone of the constitution. So protection of the liberty, for example, if the court is if no one believes on the court, that the court could not able to fulfill the just system, then what happened? Individual liberty might get, you might be pickpocketed, you might be kind of the encountered with the crime. So such kind of the system takes place, then that is called as very much unjust system as a whole. So that is the second this one theme of that. And the third one is to protect the fundamental rights of the citizen, liberty as a whole, fundamental liberty as particular, fundamental rights as a whole. So to protect the fundamental rights of the people, what are the fundamental right? That one, article 14, article 12 to article 35 of the constitution define various fundamental rights, like right to equality from article 14 to 18, right to 21, then 21 to 25. So various types of the right to equality, right to freedom, then the right against this one, labor, like this one, many kind of the right to freedom of religion. So a lot of fundamental rights are there. So to protect that kind of the rights, so justice system was to create a fair society or a just society as an entirety. If I have to take, what is just society? In which everyone feel that I am living with a due fairness, or some I'm not being cheated within the society. So otherwise, what happened? It has a huge repercussion. Civil war might take place. It might going to end up with the kind of the chaotic system as a whole. So to protect some kind of the system, that is what the objective of the justice is about. Then how to administer the justice? What kind of the traits must be there to administer the justice? For example, there must be a free and fair judicial system must be there. There must be independence of judiciary. So there must not be any kind of the intervention must be there. Corruption must not be there. And any kind of the free institution must be there. So judiciary as an institution, free from these legislative and executive interventions must be there. So there must not be corruption. So such kind of the things is there. And the second one, there must be set of law should be there. Codified law must be there of the system. Law, who makes the law? For example, now parliament makes the law. Before, the king used to make the law. Judges started making the law. There are many kind of if you look at the Vishaka guidelines case, if you look at the Vineet Narayan case, there are kind of the things which might have done by the executive, have done by the court, but the court itself cannot make any kind of the law. For example, court cannot pass the budget. Court cannot unduly create some kind of the laws which is not existed. For example, now it is going on same gender marriage. Court cannot make any kind of the law. Now it already given, but if the law is against the contradictory to the social conscience or a moral conscience of the society, it can negate the law. For example, section 377, I think Kirpal Singh case, Navtej Johar case, it decriminalized the homosexuality. So that can be done, but it cannot create any kind of the law. So what is the law? What law is there? It can interpret it, but it cannot make new laws over there. So that is how you admit. There must be a court is there. There must be a free and fair procedure is there. The two parties give the due opportunities must be given. For example, in the Kasab cases, when the whole country is against that, whole evidence is there and the video is there. There are various this one evidence is there. Still, Kasab gave the chance after the Bombay Taj Hotel blast. Why he given the due chance? That is to give the that is also a principle of natural justice, in which the two parties must be given the fair opportunities must be given to the two parties. This is how you're going to administer the justice. Okay, if you could not able to follow the law of the land, you are going to get punished. Either a civil punishment is there, the criminal punishment is there. In the criminal justice, there are various theories of the punishment is there. Let us look at one by one, and let us look at what kind of the punishment we are going to get if we go against the kind of the law. Like if we do any kind of the crime, what is the theory behind that? What is the if we are going to get the punishment if we break the, like if we do murder, if we do any kind of the stealing, so some kind of the things, if it is contradiction to the criminal law of the land, we are going to get punished. What is the theory behind that? What is the perception behind that? Let us look at it.
theories of the punishment. The first is that this one is deterrent theory. Deterrent theory. Deterrent theory. Deterrent theory.
What is meant by deterrence? Deterrence means nothing but creating the fear. For example, this one, if you read the nuclear law, I don't go much beyond that. That is a term called as nuclear deterrence, because nuclear is such a weapon in that it is going to create kind of the chaos or a kind of the generate a lot of fear. For example, if I punish some person, okay, if I punish a person A, if a person conducts any kind of the rape, murder, such kind of the heinous act, if I am going to punish him, the society get fear that one or other day, if I am going to make such kind of the similar offenses, I am going to get punishment in a very similar passion or a similar manner. So I get kind of the fear. I get scared of to do such kind of the commitment or such kind of the offenses in the future time. So that whole society get maintained through the deterrence. This theory talks about, this is called as deterrence theory. Deterrence theory talks about like that. For example, in the Islamic State, if you go there in the Syria, and now also it is prevalent that if you steal something, if you been caught by stealing some products, you are pelted with the stone. If you do any kind of the murder, you are going to be killed by pelting the stones by the society. So that whole society thinks like that. If one or other day, if I do such kind of the similar crime, even I'm going to get punished in a very much similar fashion or a similar kind of the things. If you go to the Rome in the previous time, if the woman commit kind of the adultery, and she is going to be punished by throwing the stone. If you watch 1970 movies, you will going to get that. Okay, fine. Then that is what the deterrence theory talks about. In the France, if you go in the 17 or a time of the Napoleon time, there was a machine called as guillotine machine. In that, the head being put and cut in front of the public, so that if you're going to do such kind of a crime and you are going to get punished. That is what the deterrent theory is or talks about. Then second one is preventive theory. Preventive theory. What preventive theory talks about? Preventive theory talks about, second one is preventive, first one is deterrence theory, and the second one is preventive theory. And the second theory is preventive. Preventive means what? If you are going to get punished, so that I am not going to do the person who is behind the bar, if he comes once again out of the bar or once again out of the jail, he is not going to do the similar kind of the crime. For example, if one give the capital punishment, the offender will not going to get crime one more time. That is what the preventive theory, that prevent the person from doing the similar offenses. So if someone is behind the bar, he or she will not going to do the similar crime once again. That is what the preventive theory talks about. It is also same kind of the deterrent theory. The person himself get feared. Like once if he get the punishment, after going out of the jail, he will not do such kind of the things. But practicality will be different. When it is just a theory and practical always be contradiction to the each other. And the theory believes that a preventive theory, if someone is put behind the bar, he will not going to do the similar kind of the crime one more time. That is what the theory talks about. The third one is about this one, retributive theory. Retributive theory. What retributive theory talks about is that tit to tat policy. If you do some kind of the murder, you are going to get the same kind of the punishment for that. If you are going to steal something, you are at the similar fashion of the crime punishment you need to give. It is just like eye to eye or a tit to tat policy. Some kind of, if you do something, you are going to get the something same kind of the offense. That is what the retributive theory talks about. Then rehabilitative theory, or this is also one more name is that preventive, rehabilitative theory, or this one more theory is that talks about the moral good of the people. It believes that the person innately good, person is ethical, person whatever the person do, he or she does some kind of the ethical in nature. So punishment must be this one, retributive theory, rehabilitative theory. You take that rehabilitative theory that talks about this one, retributive. Yeah, it talks about person are innately good. So we need to what in the, if you go to the jail, in the jail there are yoga, some kind of the education must be given to the person. And if you give 1958 Prohibition of Offenders Act, if you read that act, in that act it must be given that if some kind of the person beyond the age of 21 years, after once he go to the jail, if he does got any kind of the capital punishment, there is some kind of the changes within the person. If the person behavior and acting in a very good conscience, then he or she needs to be released from the jail for some time. If he stays in the society in a very well functioned manner, then the punishment will going to get reduced for that. That is what theory talks, rehabilitative theory talks about. So name might be different. So such kind of the name, I think name is different, like I forgot genuinely. And the fifth one is compensatory theory. So it believes there are various scholars for that. If you go to the John Locke, Kant, one more ethical scholar is there. He believed that human is inherently good. He has some kind of the ethical aptitude or a ethical functionality in which he or she lives into that. And if the rehabilitative theory, there must be a fair chance must be given. There must be a wrong might be committed due to some kind of the bad circumstances or a bad kind of the things, and he or she must be given some kind of the appropriate this one chance or opportunities must be given for him or her. Okay, the fifth one is compensatory theory. Compensatory theory, the fifth one here, you write that fifth one is compensatory theory, means compensation must be given to the victim. It is mainly followed in the civil laws. In the civil laws, if some kind of the harm is taking place there over there, if you read the tort, so there are compensation must be given. If you do any kind of the act which harms the other person, for example, there is an accident taking place, a car hit the bike, so person who is riding the bike, he will going to get the, if the person who is riding the bike is in the wrong mode or a wrong situation, the person going to get compensation from the car driver. Why such kind of the things is that just because of that the victim needs to be get compensated for that. There are various laws which deals with the given the fair amount of the compensation. I hope in the today's session of the justice class, so I hope you get the what is justice and the types of justice. There is a civil and criminal justice and the totality, like the theories of punishment is there, and there are five types of the punishment is there, theories of punishment is there. So justice, when we look at the justice as a concept, there are various scholars defining a justice in a various ways, which I wrote the definition. I do felt that this definition is most appropriate and most suitable when we look in the kind of the legal jurisprudence. And as I have given the administration of the justice, or when we look at the justice as a whole and the entirety, like when we look at the different time or a different circumstances, the meaning of the justice get entirely different. So this justice is at the present contemporary democratic institution when we look at it into it. So the future technological system might come, the future world after 100 years, 200 years might be completely different. So technological arena we are living into. So at that time, the justice, some kind of the technical word might be added over here. So justice means some kind of the fair system in which it helps us to live. It everything the justice or a law, everything is encompassed towards the social needs or a social utility. The final is that the social utility and the justice needs to make such that, that's why I added the word socially acceptable must be there, ordering of the rights, duties and power, so that human dignity, fairness and social harmony gets protected. And we look at into a natural justice, legal justice is there. There are principle of natural justice, Maneka Gandhi case. In the last class I explained about the Maneka Gandhi case. In that natural justice also I explained there must be a fair opportunity must be given. Then the legal justice is there. Legal justice means implicitly written over there. Then the types of the justice, civil and criminal justice. What is civil justice, what is criminal justice? If you do a criminal wrong, there is a separate court. Civil wrongs, there is a separate court is there. Theories of punishment is there. The deterrent theory, preventive theory, retributive theory, lot of theories are there. So that these theories, these theories are the perception, like if we put behind the bars, what kind of the changes we bring. If we punish some kind of a person, what kind of the changes the society, what kind of the impact on the society, how we prevent the crime in the future times. So theory is that, but practicality might be different. So such kind of the whole, I hope you enjoyed the video. Okay, thank you very much.